Judgment in the matter of Royal Bank of Canada against Commissioners for His Majesty's Revenue and Customs.
Lady Rose will hand down this judgment.
When oil was discovered in the part of the North Sea that belongs to the United Kingdom, two things were clear. First, that this could generate a very large income for the UK if the oil could be extracted and sold on the market, and secondly, that the government would need to call on the expertise and investment of oil companies across the world to come to the North Sea to locate, drill for, and extract the oil in order then to sell it. This case concerns whether a certain stream of income which was earned by the Royal Bank of Canada, mostly between about the year 2000 and 2017, is subject to tax in the UK. Generally speaking, the appellant, HMRC, can only tax income that is earned either by people who are resident for tax purposes in the UK or who are resident in another country but who have earned the money from a permanent establishment where they carry on business in the UK. The Royal Bank of Canada is tax resident in Canada, not the UK, and the income we are concerned with is not income that was earned by them at a permanent establishment here. Ordinarily, therefore, this income would not be taxable by the UK revenue, but would be taxed instead by Canada. However, there are special rules about the taxation of income which is derived from the exploitation of natural resources in a country. This is because it is thought that every country has a particular claim to be entitled to tax the money people make from oil or coal or other minerals or forests in their land. But the income stream has to be sufficiently connected with the exploitation of the natural resources in order for one country, in this case the UK, to be able to claim an entitlement to tax it instead of it being taxed in Canada, where the Royal Bank is resident. For our purposes, the rules on whether it is Canada or the UK which can tax this particular income stream are set out in a treaty entered into between Canada and the UK in 1978. It is called a Double Taxation Treaty or Convention, and it is one of a number of bilateral conventions entered into between countries all over the world, trying to ensure that the same earnings are not taxed in the hands of the taxpayer in both countries just because the income or the taxpayer has some connection with both countries. The idea behind a double taxation convention is that the countries agree which of them is going to tax a particular kind of income, and then the other country agrees that it will not tax that income. The provision of the double taxation convention between Canada and the UK, which is relevant in this appeal, is Article 6. Article 6 provides that income from immovable property may be taxed in the contracting state in which such property is situated, regardless of the tax residence of the person earning the income. Immovable property is usually land, but it also includes minerals under the land, including oil. Article 6(2) provides an expanded definition of what counts as immovable property for this purpose. That definition includes not only land and the natural resources, but also rights to payments, which are paid to the taxpayer as consideration for the working of, or the right to work, natural resources. The question raised by this appeal is whether the income that the Royal Bank earned, and which HMRC want to tax, is income which they were paid as consideration for the working of, or the right to work, the oil in the North Sea. The income that we are concerned with came about in this way. In the 1970s, the UK government started to give out licenses to oil companies to explore particular sections of the North Sea where it was thought that there was oil to be discovered. The government issued those licenses in return for the payment of a royalty by the license holder. The government decided it only wanted to give licenses to UK companies. That meant that if an overseas oil company wanted to take part in drilling for oil in the North Sea, it had to set up a UK-based subsidiary to apply for one of the licenses. In the early 1980s, the Canadian-based oil company called Sulpetro Limited decided that it wanted to have the chance to drill for oil in the North Sea. So it set up Sulpetro UK, a UK subsidiary. Sulpetro UK was granted a licence by the UK government to explore a particular section of the North Sea continental shelf known as the Buchan Field. There was a written contract between Sulpetro, the parent company, and its subsidiary Sulpetro UK, in which it was clear that all the money and the expertise would be provided by the Canadian parent Sulpetro, and if any oil was found, then that oil would be owned and sold by Sulpetro to reward it for its money and effort. But it was always Sulpetro UK which held the licence and paid the royalty to the UK government. In 1986, BP bought Sulpetro UK from Sulpetro and also acquired all the rights and obligations that Sulpetro had had under its contract with its subsidiary. Part of the payment that BP made to Sulpetro in return for acquiring the subsidiary company and the rights under that contract was a series of payments, and it is those payments that are subject of this dispute. The payments under the contract worked as follows. Under that sale contract between Sulpetro and BP, BP promised that if it actually found any oil in the Buchan Field, and if the value of that oil coming out of the field rose above $20 a barrel, BP would pay Sulpetro a certain amount for each barrel of oil it won from the field. When Sulpetro went out of business in 1993, the Royal Bank of Canada acquired the right to receive those payments from BP. For many years, there was no oil coming out of the Buchan Field, or at least no oil that could be sold for more than $20 a barrel. But as from the year 2000, when the international oil price went up, BP started paying sums to the Royal Bank of Canada each quarter pursuant to that agreement. Those payments lasted until the Buchan Field ran out of oil in 2017. HMRC claimed that those payments made by BP to the Royal Bank of Canada are taxable in the UK because they fall within Article 6(2) of the Double Taxation Convention. They say that the rights that Sulpetro originally had in its agreement with its subsidiary Sulpetro UK fall within the phrase rights for the working of or the right to work the oil in the Buchan Field. That in turn means that those rights are within the definition of immovable property in Article 6, so that it is the UK and not Canada which can tax the consideration that Royal Bank of Canada received, even though the Royal Bank is a Canadian company. The Royal Bank of Canada says that those payments are too remote from the actual working of the oil or from the right to work the oil to count as immovable property, and that the payments are only taxable in Canada. Both the First-Tier Tax Tribunal and the Upper Tribunal held that the payments were within Article 6 of the Convention. They held, therefore, that Royal Bank had to pay tax on the payments to HMRC. The Court of Appeal allowed the Royal Bank's appeal and held that the rights that BP had acquired and for which it was making the payments did not amount to the right to work the Buchan Field. They held further that the payments were not made as consideration for any right to work. HMRC now appealed to the Supreme Court. The Supreme Court, by a majority of 4-1, dismisses this appeal. First, on the issue of whether the rights that BP paid for fell within the meaning of right to work under Article 6(2), this court holds that they did not. It was Sulpetro UK that held the licence to work the Buchan Field, and not the Canadian parent company Sulpetro. And it was the UK company that had all the rights and responsibilities that arose under that licence. Sulpetro UK and not Sulpetro had the right to work the oil. There is a legal difference between someone having a right to work natural resources, which is what Sulpetro UK had, and someone having a right to require another person to work those natural resources, and that is what Sulpetro had. It is true that it was the parent company Sulpetro which put in all the money and expertise and got all the oil. But the whole of our tax code, and tax codes generally across the world, are based on the fact that as a matter of law, every company is a separate taxable person, and you do not generally treat the owners of the company as being the same person as the company. The separate legal personality of Sulpetro UK as the licence holder from Sulpetro the parent cannot just be ignored unless there is a particular statutory provision that tells you to ignore it and sets out the circumstances in which you can treat them effectively as the same person. The first-tier tribunal and the upper tribunal gave as part of the reason why they gave such a broad scope to Article 6.2 that otherwise it would be easy to avoid paying tax on the payments by setting up arrangements of the companies in a certain way. But this court says it's important to bear in mind that the UK-Canada Convention does not determine whether a particular stream of revenue should be taxed or tax-free. Instead, it identifies where the boundary lies between, on the one hand, Canada's power to tax the profits attributable to a Canadian business of a Canadian resident company, and on the other hand, HMRC's power to tax profits which derive from the exploitation of the UK's natural resources. There is nothing within the UK-Canada Convention which indicates that one must identify the right to work and attribute that right to the entity which invests its funds and sells the oil, when that is not the entity which is licensed by the government. There was another point raised by the appeal which would only be relevant if we had held that the payments in dispute were within Article 6.2. HMRC can only tax income if there is a specific provision in our domestic legislation that allows it to do so. It would not therefore be enough for them to establish that the UK had a right to tax the payments under the Convention. They would also have to show that the UK has taken advantage of that right by including in the UK tax legislation a power allowing them to tax it. HMRC rely on Section 1313 of the Corporation Tax Act 2009 as the section which allows them to tax whatever income the UK can tax under Article 6 of the Convention. The court holds that, if contrary to what we in fact decided, we had decided that the payments in dispute did fall within Article 6.2, then Section 1313 of the UK Act was drafted broadly enough to catch them. As it is, the court dismisses the appeal and decides that the payments cannot be taxed in the UK, they can only be taxed in Canada.